We're going to start with a very brief introduction to administrative law, just to cover the purpose of administrative law and how it relates to the various branches of government. So administrative law refers to the departments and agencies of the government, and for this introductory lecture, assume I'm referring to federal administrative law. So an agency is defined by the Administrative Procedure Act as each authority of the government of the United States, whether or not it is within or subject to review by another agency. It then goes on to exempt Congress, the courts, and the governments of D.C. and the territories, and in 1992 the Supreme Court excluded the president from this definition as well. So the president appoints cabinet members, and these cabinet members are responsible for various departments. For example, Homeland Security, Health and Human Services, Transportation, Labor, Agriculture, and so on. Within the departments are agencies such as the United States Forest Service, the FDA, the FBI, the IRS, and the CDC, and there are really too many to name. Some agencies, like the CIA and the U.S. Postal Service, exist outside of departments, but still are considered part of the executive branch. Independent regulatory agencies are outside of the executive branch but still serve an executive function. For example, the FCC, the SEC, and the Nuclear Regulatory Commission. So what makes agencies like these independent is that they are headed by multi-member groups as opposed to a single director or administrator. No more than a simple majority can come from one political party. Group members have fixed, staggered terms, and they can only be removed from their post for some reason. So independence in this case refers only to independence from presidential control. Members of independent regulatory agencies can't be removed from their post simply because they don't share the president's vision or because a new president has been elected. Departments and agencies, independent or not, serve an executive function. They enforce or implement laws. Agencies handle the details. So a law is passed calling for regulation of some activity. Members of Congress don't have the time or experience to get into the details of this regulation, so that is left to an agency. Agencies do this by implementing and enforcing rules. These rules look like and have the force of statutes. An agency may also engage in adjudication where applicable or may issue licenses. They may also perform investigations to obtain information or data to support their actions, whether it be in the rulemaking process or the adjudication process. The authority of an agency is determined by the Due Process Clause of the Constitution, the Administrative Procedure Act, and enabling legislation. Agencies must act within the limits of the Constitution. However, the Constitution does not actually specify rules or limits for agencies. So in 1946, Congress passed the Administrative Procedure Act. The APA followed Roosevelt's New Deal legislation, which saw the creation of many new federal agencies. And the APA was passed in an effort to regulate and standardize agency procedures. An enabling act, sometimes called an organic act, is passed by Congress and it gives an agency its authority. Enabling legislation will specify an agency's responsibilities, how the agency will be governed, and how members will be chosen for or terminated from their posts. For this unit, we'll be covering the Federal Register and the Code of Federal Regulations. The Federal Register is a daily publication of the executive branch. This is where regulations and proposed regulations are published. Then regulations are codified in the Code of Federal Regulations. And you can find the official version of the CFR online at the GPO's Federal Digital System, or FedSys. And the Administrative Law Review is a secondary source we have available in the library. It's published by the ABA. So there are numerous regulatory agencies at the federal level alone. Why so many? Well, agencies have more flexibility. They have to work within the confines of the APA and due process, but they can work more efficiently because they specialize. Agencies are staffed by specialists and can call upon their expertise to put forth these regulations. Agencies work because they respond to the changing social landscape. So in the early 20th century, there was a necessity for regulation of monopolies. The New Deal in the 1930s saw the creation of new agencies in an attempt to stabilize the economy and unregulated markets. World War II called for regulation of production, price controls, and rationing, and in the 1960s, poverty, and racial discrimination were addressed by the creation of federal programs. So in the 21st century, social concerns are related to human health and safety and the environment, and possibly the zombie apocalypse will be addressed by an agency. So what's the downside to these specialized, seemingly efficient bodies? Some of their strengths may be seen as weaknesses. Their narrow field of specialization may lead to tunnel vision. Some believe agencies operate unchecked or arbitrarily, and they make red tape. So where do these agencies fit into the grander scheme, and how do they interact with the branches of government? Again, they serve an executive function. They enforce the law. They either belong to the executive branch or work for the executive branch. And they are given authority through enabling legislation. And they can be subject to judicial review if it seems like they are acting arbitrarily or outside of statutory limits. And the APA legislation specifies the scope of judicial review. So if you want to know a little bit more about administrative law, the library has some good resources. We have the Examples and Explanations, the LexisNexis Understanding series, and the West Nutshell series, and they all have editions devoted to administrative law. And we keep these on the reserve shelf in the Commons area by the reference desk.